Fundamental to the American constitutional order is an independent judiciary. By independent, we mean independent of the other branches of government. That is, judges exercise their office without fear of reprisal from the executive or the legislative branches. We understand this as fundamental today, but it has not always been so. In fact, it would be improper to speak of the judiciary or the judicial branch as independent in any real sense in the period of the founding. So how did the independent judiciary come about? One of the legacies of the Revolutionary era was a fundamental distrust of judges. It was, after all, the judges who had been seen as the main enforcers of British policy. They were bound by parliamentary law, and they enforced it without any question. Remember the writs of assistance case? James Otis may have argued against the constitutionality of the writs of assistance, but he was rebuffed by the judge. Same in the Zenger trial of several decades before. It was the jury, not the judge, that had proved the real bulwark of liberty. Accompanying this suspicion was the sorry state of the judicial profession. Very few lawyers had real training, and judges often did not either. Nonetheless, the legal profession had taken steps to increase its respectability. Lawyers in Massachusetts, for instance, were required by the legislature to take an oath of office in 1710. Even then, however, a young John Adams noted that in the 1750s, the Massachusetts countryside, there he found, quote, the practice of law was grasped into the hands of deputy sheriffs, pettifoggers, and even constables, who filed all the writs upon bonds, promissory notes, and accounts, received the fees established for lawyers, and stirred up many unnecessary suits. In short, Adams was saying, there were no real lawyers in the countryside. And this was despite the fact that the Massachusetts County Bar Associations had required of their members a college education, a 3-year apprenticeship in a law office, and the recommendation of the Bar Association before being called to the bar to practice law before the inferior courts. After several years of practice, lawyers could then apply for admission to the bar of the Superior Court of Massachusetts. So the judicial profession was beginning to organize, but it was not institutionally stable. It may have been for these reasons that the judiciary was not considered so important. The first national government organized under the Articles of Confederation did not even have a judiciary. When Madison's Virginia plan was unveiled at the Constitutional Convention, judges were not prominently placed. They were to have tenure at good behavior and a fixed salary and a jurisdiction consummate with that of Congress. Judges also had jurisdiction over cases of impeachment of federal officers, a dead giveaway, by the way, that Madison had cribbed the national judiciary from the Virginia Constitution. The small state New Jersey plan also included a national judiciary, and we may conclude from this that everyone understood the need for a national judiciary that would have jurisdiction over national affairs. In short, the Articles of Confederation, everybody agreed, had been defective for not having a national judiciary. But what about the judiciary's power? Would it be a truly independent branch of government? Or would it merely enforce the laws passed by the legislature? Recall that the elephant in the room in Philadelphia was the small state delegates' fear of consolidation, the idea that the national government would swallow up the states. This was why many of the strong checks against the power of the states were ultimately rejected. The most powerful check that Madison had included in the original Virginia plan was that of the congressional veto of state legislation. The New Jersey plan had countered this with a clause that would come to be known as the Supremacy Clause, the idea that judges would hold the power of vetoing state laws that improperly collided with national powers. James Madison objected to this during the convention. He called it a weak check. If one had to wait for a judge to strike down a law, Madison argued, the mischief might already be done. Madison was likely also aware that judges lacked the strength to take on powerful local interests. This was the context for the major discussion of judicial review at the convention. It was the striking down of state laws that contravened the national constitution and the laws of Congress. That bears repeating. The context for the major discussion of judicial review at the convention was how to enforce the supremacy of federal law against states. James Madison wanted that check to be in the hands of Congress, by all accounts the most powerful of the branches of government. The small state counter to this was to put the check in the hands of state judges rather than the National Congress. The result was something stronger than the small states wanted, but nonetheless a weaker check than James Madison had himself wanted. But if judicial review was initially intended as a check against unwise and unconstitutional state legislation, then did the courts have the same check against federal statutes? Could judges declare laws passed by Congress to be against the Constitution and thus void? Clearly, some delegates to the convention believed that the federal judiciary would hold such a power, the power to be able to strike down federal law as unconstitutional. James Madison's initial Virginia plan included a council of revision that would be composed of the executive and a, quote, convenient number of the national judiciary, end quote, that would have the authority to veto a law for constitutional reasons. This was ultimately nixed, with some members wondering aloud whether it represented an improper mixture of powers. In the end, the check on congressional legislation for both policy and constitutional reasons was left solely in the executive, although a congressional supermajority could override a presidential veto. But this was not, of course, the only check on Congress. Bicameralism was itself a check. So too was federalism. Curiously, though, in the Constitution's text, the judiciary was not explicitly given the power to veto laws as unconstitutional. The independent judiciary as a concept turned out to be not such a big deal during the ratification debates. Anti-federalists who worried about consolidation did not think the national judiciary a threat. They did complain about the vaguely defined, life-tenured national judiciary that would interpret state law in such a way as to subvert state sovereignty, but mainly because they were concerned that the judiciary would use the Constitution of the United States in order to subvert congressional law. Interestingly, some anti-federalists wanted the legislature to be the final voice of interpretation of legislative law. Alexander Hamilton answered this argument in Federalist 81, noting that, quote, there is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, end quote. There is also the famous argument that Hamilton put forward in Federalist 78, making the case that the national judiciary would help protect the people from an overzealous Congress. But Federalist 78 came late in the game and did not really play a major part in ratification debates. More important than Article III for the future of judicial power was the 1789 Judiciary Act. In addition to setting the Supreme Court size and establishing the framework for judicial power, there was an extraordinary provision lodged in Section 25 that extended the jurisdiction of the Supreme Court over the Supreme Courts of the states. Had this provision been in Article III, it certainly would have been attacked during ratification by the Anti-Federalists. And there is nothing in Article III or in the Supremacy Clause that suggests that Section 25 was inevitable. The first nominees for judgeships often came at the recommendation of senators, people who wanted to serve on the court asked senators to advocate for them. They were not shy about it, as the distribution of offices, however small, was an important act of patronage. George Washington, in a precedent-setting move, consulted the senators about nominees from their home state. This was a senatorial courtesy he extended them, and it continues to this day. The Senate did take its role in the appointment process seriously. Not every nomination of President Washington was approved. Most famously, John Rutledge was nominated in 1795 to take the place of John Jay as Chief Justice. He served in that capacity for 4 months as a recess appointment, but the Senate withheld its consent when it came back into session. The life of a Supreme Court justice in the 1790s was not easy. The total compensation for the United States Supreme Court's 6 members was $21,500. This is the total compensation for all 6 members. The figure was not raised until 1819, when Congress awarded the justices $33,000. There was no provision for staff, or fees, or expenses. All of this money was paid in salary. Supreme Court justices spent only a couple of months in the Capitol. The rest of the time they rode circuit, meaning that they sat on a circuit court in a particular geographic region where they behave much the same way a regular district judge would. No wonder John Jay quit the Supreme Court in 1795 to serve as governor of New York. And remember John Rutledge? He had originally been Associate Justice of the Supreme Court. He resigned in 1791 to serve on the Supreme Court of South Carolina. So Supreme Court Justice, at least for the United States, was not necessarily a great gig. The early court had barely any business, but it did hear some very important cases, and it made some very important decisions. Let's review a few. One of the first was Heyburn's case in 1792. Congress had created a pension board to hear the petitions of Revolutionary War veterans. But, lacking an efficient bureaucracy, Congress delegated the authority to hear the petitions to the Supreme Court, effectively making the justices pension officers. The justices protested. This was a law that effectively added burdens to their branch. Importantly, it gave them non-judicial duties. So they wrote private letters to President Washington protesting the law and refusing to carry out the duties. The principle? The court could protect its institutional prerogative. Another case was Elke v. Ives and Moss. This was not a Supreme Court case, but a circuit court case. A free black father in Massachusetts sued two Connecticut slave traders for carrying off his daughters. The circuit court took jurisdiction under diversity jurisdiction. This is that clause of the Constitution that allows the citizens of two states to bring a case directly to a court of the United States. A jury in the case awarded Elke damages, and his daughters were returned. The principle? Free blacks are citizens for the purposes of diversity jurisdiction. In Ware v. Hilton, 1796, the court held that treaties were superior to state laws. In Hilton v. United States, the court was asked to strike down a carriage tax because, as a direct tax, it needed to be proportional. The court declined, holding that the tax was not a direct one and therefore was not bound by the constitutional provisions in question. And in Calder v. Bull, the court read the ex post facto rule of the Constitution very narrowly to avoid declaring a Connecticut law unconstitutional. However, Justice Samuel Chase hinted in Calder v. Bull that the Ninth Amendment would protect basic rights against oppressive laws. This was an early indication that there could be a Ninth Amendment jurisprudence. But the court's most visible case came with Chisholm v. Georgia. You have this case, so we will consider it in class. The case's lasting impact, however, was not in any holding of the court. Rather, it was in the reaction that the case inspired. Chisholm began when an individual sued the state of Georgia. The state of Georgia refused to admit that it could be sued in court without its consent. Although the Supreme Court moved forward with the case and held it in Georgia's absence, the end result was passage of the 11th Amendment to the United States Constitution. In other words, when the Supreme Court did try to act against powerful actors like the states, they found themselves being rebuffed, in this case, by Article 5 procedures.